Second day of the workshop refresher on IBC. Today we are going to deliberate on the topic pre-packaged insolvency and other matters with Partha Kamal Sen sir. I would like to read his brief profile. He's fellow member of ICAI, associate member of ICSI, a law graduate, also passed the limited insolvency examination of IBBI, certification course on commercial mediation from Chartered Institute of Arbitration, UK. He has more than 35 years of experience in industry in the area of corporate secretarial, legal, accounts and finance, audit, risk, and claim management. He worked in Siemens, Phoenix, and PricewaterhouseCoopers, etc. He has experience as an IP since June 2017. As IRP and RP, he has handled the case like Burn Standard Company Limited. As IRP, he handled OHIO Cardiology Associates India Private Limited, Force Gunch Food Processing Private Limited, Pincon Spirits Private Limited. Currently, he's an insolvency professional and a practicing company secretary. So it's a pleasure to have you in the workshop as the faculty. And now over to you.
Yeah, thank you, Anjali. Thank you for your words of wisdom. So, good morning to you all. I am audible?
Yes, sir. It's perfectly fine.
Okay. So, I welcome you all for this.
Good morning, sir.
Good morning. Good morning. So, I welcome you all in this workshop. I think at the outset, I thank ICSI IIP for their invitation. I think it is a great initiative on the part of the institute to organize such refresher course. You know, it is said that if you want to utilize your brain to its fullest capacity, one should learn, unlearn, and relearn. So this type of refresher course, I think, gives us the opportunity to relearn the subject. So friends, frankly, when I prepare my presentation, really I come to know, I mean, I recapitulate many things which I know but gone out of my mind. So it is really very helpful for all of us. Also, I think it is a good endeavor to invite the company secretaries for this program, because the topics which we will discuss are the most important topics for the insolvency code. And you know, nowadays the many people come for the consultancy on this subject. And I am sure the practicing company secretary having knowledge on this will be in a better position to advise the clients. So anyway, let me share my presentation I prepared for this. Is it visible? Hello? My presentation is visible.
So far
No,
the presentation
sir, not visible, sir.
Not visible. Just a minute. Is it visible now?
Yeah, now it's coming. It's visible.
Yes, sir. Yes.
Okay. Thank you. So today our program is personal guarantor in the individual insolvency and prepackaged insolvency. It is a whole day session. I mean, I will speak in both the first half and second half. So what I suggest that we will first discuss about the personal guarantor and individual insolvency in this first half, and in the second half we will discuss the prepackaged insolvency. Okay. So let's start. Just let me make it the full screen. Yeah. So at the outset, some disclaimer from my side that the opinion expressed or the interpretation made in this presentation are purely my personal, and even the interpretation which is made in this for the case laws are my personal one. And I request that one should not give any reference to any legal matter out of this presentation. So friends, I propose to cover the session in the following way. First of all, we'll discuss the very briefly the evolution of IBC and the framework of IBC. Then we'll discuss the chronology of personal guarantor induction. Then changes brought by the notification dated 15th November 2029. Then we'll discuss the processes to personal guarantor. We'll discuss the timelines for the processes. We'll discuss the provisions for bankruptcy and the adjudicating authorities, that is NCLT and DRT. And lastly, we'll discuss the comparison with other processes under IBC. And if time permits, definitely I'll keep some time at the end of my discussion for the question answering session. Even then, I request you that kindly make the session as an interactive one. Whenever the question arises, you please ask me, either you put your question in the chat box or you can unmute yourself and ask me the questions. And it should be appreciated that it will be easier for me to answer you along with the slide of presentation. So with this, we'll start. I think all of you agree with the coverage. So friends, when prior to introduction of IBC, there are lots of laws and acts available in the country to address the insolvency issues, like your Sikh Industrial Company Special Provisions Act, then Provincial Insolvency Act, Presidency Town Insolvency Act, your Bad Debt Recovery for Bank and Financial Institutions Act, SURFACE Act, Companies Act. All acts are available there for the resolution purposes, insolvency resolution purposes. But the problem is that all these acts or laws are standalone. They operate on a standalone basis. What I mean by this, that they address to a particular segment. Like SICA address the Sikh industrial companies. It is called the Sikh industrial companies. Provincial Insolvency and Presidency Town Insolvency Act for the individuals insolvency. Bank, even our Companies Act also address to the resolution process for the companies. So they operate in a particular field. It's not a comprehensive one. And moreover, what's happened, these acts are not complementary to each other. That is to say that, one can file a case against a person under an act, and the same person can file the case for that person under another act. That is possible, in the earlier reason. So what's happened is, when the order comes under for a petition, nothing can be done unless until the decision for the other petitions will also in hand. So this becomes the affair very time consuming, and to get rid of these things, the government of India was looking for a comprehensive and consolidated act to address the insolvency process within the country. Not only in the insolvency process, government of India is also looking for the ease of making exist for the business operations. The companies which are really not viable, or which don't want to continue with their business, so how quick they can go out from the scene. That is also the intention for the government of India. And all these things are for the purpose of increase the status of the country in the list of ease of doing business as prepared by the World Bank. So what's happened, government of India in the year 2014, more precisely on 10th July 2014, announced the formation of a company called Bankruptcy Law Reform Committee. And on 10th November 2014, the committee was set up by the government under the chairmanship of Mr. T.K. Viswanathan, who is the former Secretary General of the Government of India in Parliament and also the Principal Secretary of the Minister of Corporate Affairs. So under his chairmanship, this BRRC is set up. The committee submitted their report on 4th November 2015, and the report was discussed in both houses of the parliaments, and they cleared the report and sent it for the presidential consent, accent on the bill. And finally, the notification came for the IBC on 28th May 2016, and IBC was made effective from 1st December 2016. So this is in brief the recapitulation of the evolution of IBC in the country. So as per my discussion, you can understand that there are some unique propositions of IBC. This is unlike the earlier laws which are available in the country for addressing the insolvency or the exist provision of the for the business entities. So what are the unique proposition of IBC? First, it is a consolidated law. It can address everyone. It is meant for everyone. It indicates the time-bound process. The timeline for each and every action is indicated in the code itself. It maximizes the value of asset value of the corporate data. It promotes entrepreneurship. It makes the credit availability, and it balances the interest of all stakeholders within the process. So these are the unique propositions for IBC. So here I just stop. I just stop for 2 minutes, and I ask you, what do you think? Which proposition or propositions which lead to our today's discussion? Out of these 6 propositions which I am showing to you, which one leads to our today's discussion? You please tell me. I just watch my word for 2 minutes. You can put that now. You just put the number 1, 2, 3, 4, 5, 6 in the chat box so that I can see it. Just I cannot see the chat box. Hello? Hello, you can hear me? Hello? Hello?
Yes, sir, we can hear, sir.
But I cannot
Yeah, you can hear it, sir.
but I cannot access the chat box, right? Just tell me, then you can just tell me which proposition you think that lead to today's discussion.
6 and balancing all.
Balancing all, okay? Then
Balancing all, sir.
balancing all. So okay, thank you. Just a minute.
All others are embedded, sir. All the others are embedded. For example, if you say maximization of assets values, that is embedded. Time-bound solution guys have said that is coming. So it is an embedded one.
So according to you, all the propositions, I mean, lead to that this process, the insolvency process for the personal guarantor, isn't it?
Yes, sir.
Okay, but just a minute. Okay, no problem. So, friends, the proposition which lead to today's subject, how can we make it stop share? How can we make it full sharing? Is it okay if it is in this way? I mean, the presentation, I cannot make it full sharing. Oh, that's, yeah, sorry, I got it. Yeah, I got it, yeah. So friend, the proposition which lead to today's subject is first, number 3, maximization of asset value, and fifth, the credit availability. You know what's happened when IBC was introduced and make it functional. There are huge haircuts while approving the resolution plan. The financial creditors bear huge haircuts from the resolution plan submitted for the revival of the corporate debtor. There are various reasons. We will not go deep in this. Maybe the asset value really depleted at the time of submission of resolution plan. But it is the fact that there is a huge haircut. I think in the case of Bhushan Steel, it is more than 90%. So this really worries government of India. So they asked the working committee for IBC to find out the solution. And as per the working committee report, they find a nexus between the personal guarantor and the corporate debtor for inducing bank to make them the loans. So they suggest, since personal guarantor are also involved in the process of granting the loans, so why can't we have the framework, legal framework, to recover the shortfall from the assets of the personal guarantor? And more so, friends, we will discuss it later, that as per the Contract Act, the liability of the guarantor or surety is coexistence with the principal borrower. So they said, we have the framework by which the money, the shortfall in recovery can be taken up from the assets of the personal guarantor. And you will appreciate that this will definitely maximize the asset value of the corporation. More recovery means more asset value. And creditability, as the result of which bank will get more finance and they can finance it out to the others. So these two propositions lead to the framing of rules and regulations and changing the act, including making the amendments in the act towards the personal guarantors insolvency process. Okay. So friends, I mean, I'm sure you know that our IBC is divided into 5 parts. The part 1 is the general one, which gives the general definitions and it covers the section 1 to 3. Part 2 is the provisions related to corporate insolvency for the companies and LLP. It has 7 chapters covering section 4 to 77. And part 3 is actually our subject for discussion, which is for the individual insolvency. It also divided into 7 chapters, chapter 1 to chapter 7, and running from section 78 to section 187. Part 4 is the authorities. This part discusses the authorities of various forum, like your IGBI, then IPA, information utilities. And part 5 is the miscellaneous, which runs into the section from section 224 to 255. So more or less, this is the framework under which the IBC operates. Yeah, whenever I make the presentation friend on IBC, I always put this slide. I believe that by going through the objectives of the code, which is given in the preamble of the code, one can explain, one can analyze each and every actions and transactions under the code. Everything, all decisions, everything can be analyzed, can be interpreted with the help of the objective. So what is said, that it said that it is the of the IBC is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all stakeholders, including alteration in the order of priority of payment of government dues, and to establish an Insolvency and Bankruptcy Board of India, and for matters connected therewith or incidental thereto. I think it is a, I mean, it can explain everything. It can explain everything, each and every matter under IBC. What we deal in the IBC, be it enacted by Parliament in the 67th year of Republic of India as follows. Okay. So here I have underlined two things: one for maximization of value of assets and availability of credit, which we have already discussed. That these two things are very important for our today's discussion. So if you have any question, please ask me. Okay. I think all of you know that when IBC was notified on 28th May 2016, the majority portion of the IBC was notified at that time, except the part 3, which deals with the individual insolvency. And many reasons are there. Maybe one of the reasons is the infrastructure issue for dealing with this problem matters. But it was not so at that time individual insolvency was not notified, and so nor the process for the against the personal guarantor. But after the report of working committee, what I told you, the government of India, they introduced these provisions for the personal guarantor by incorporating them as the individual insolvent. They incorporate, if you see part 3, there is no reference of personal guarantor. So government of India, while introducing the process for them for the personal guarantor, they incorporate them as the individual insolvency and they incorporate them in the part 3 of the code. So on 26 April 2019, the draft regulation for insolvency and bankruptcy process of personal guarantors of the corporator was framed. On 8 May 2019, draft rules of insolvency and bankruptcy process of personal guarantors were framed. Then 15/11/2019, the sections of the core rules of personal guarantors were notified. So the personal guarantors provisions were notified through the notification number SO 4126E on 15th November 2019. And 2011-2019, the regulations, IBBI introduced the regulations for the personal guarantor insolvency process, and it is also notified. And the entire thing, the rules, code rules and regulations, entire thing was made effective with effect from 1st December 2019. So this is the chronology of personal guarantor. Though it was not introduced at the time of the introduction of the main IBC provisions, but later on government introduced this thing only for the personal guarantor. So let's see the notification, what it mentioned. I mean, the salient features of the notification are captured here. So notification number SO 2146C dated your 15 November 2019, the state notification came in force, and the action sections came in force or amended through this notification. What are those? First, the section 2 clause E, which is the applicability of code, which denotes the applicability code. the section clause Z 2 clause Z was amended by incorporating the personal guarantors to corporators. So as per that amendment, the code is also now applicable for personal guarantors to corporate debtors. Then section 78, except with regard to the fresh start process, and section 79. Section 78 is the applicability of the personal insolvency process for the individual, and section 79 indicates some definitions for that. Then application of the chapters and definitions as given in the code for relevant chapter also applicable. That is section 94 to 187. All are made available. Then insolvency bankruptcy process for personal guarantors. Section 239 to clause G to I. Section 239 clause G to I is the rules made by the central government in respect of the relative value unencumbered single dwelling unit and value of any other debt for the personal guarantor. So this is, section under by section 239. The central government is empowered to frame the rule. So by amending section 239 to clause G to I, the central government frames rule for mentioning what is meant by relative of the personal guarantor, value of unencumbered single dwelling unit, etc., etc. Then the amendment made in section 239 to clause M to ZC. It is rules made by the central government on application or other documents for the process. Then section 242 clauses ZN to ZS. Section 242 is the section which empowers the IBBI to make the rules. So power to make regulations by IBBI for personal guarantors are also incorporated in the code. Section 249 is the amendment to be made in the Recovery of Debts Due to Bank and Financial Institutions Act. When the IBC was introduced, there are lots of amendments made in other acts also to incorporate IBC. I am sure that all of you are aware that IBC has an overriding power, section 238. So in order to give effect to that particular section, many acts like your Income Tax Act, your Customs Act, many acts were amended to incorporate the provisions of IBC, supremacy of IBC in those acts. So by amending section 249, the necessary amendment was made in the Recovery of Debts Due to Bank and Financial. So notification number SO 4126C dated 15 November 2019 brings the incorporation of this section or the amendment to the section in the code. Friend, I am sure that you are aware of this case law, but as we are now organizing a refresher program, so I once again want to discuss this case law with you. When the notification was published for the insolvency, personal guarantor insolvency process, resolution process, through that notification dated 15/11/2019, there is a hue and cry, and which is quite natural because it is like somebody has thrown pellet to the honeycomb. So there are hue and cry raised in the country. The persons allege that this notification is anti-constitutional, is a violation to the constitutional rights provided to the citizen of India. Like they say that this notification violates section Article 14, which talks about the rights to equality, Article 21, which provides for the rights to the corporate life and the individual property. They said by this notification, all these articles are violated. So it is an anti-constitutional provision made by the government of India. And the main reason is that what I told you also earlier, that part 3 of IBC, which has been made available to personal guarantors, deals with insolvency, bankruptcy of individuals and partnership firms, and not for the personal guarantors per se. So they raised the violation of Article 14, that right to equality is gone out of this notification. So multiple petitions were filed in various high courts challenging that constitutional validity of the said notification. The crux of the argument of the petitioner is that provisions governing insolvency and bankruptcy of individuals and partnership firms cannot be made selectively applicable to the personal guarantors. What I told you just now. They said it cannot be made applicable because that part 3 is only for the individual insolvency, not for the personal guarantors. So due to bulk writ petitions filed before the High Court, IBBI applied to Supreme Court to deal with the law point of the matter in a holistic manner. The Honorable Court in Lalit Kumar Jain versus Union of India and others held that the said notification dated 15/11/2019 is legal and valid. The apex court put the seal on the constitutional validity of this notification by the judgment in this case, Lalit Kumar Jain versus Union of India and others. The apex court said approval of a resolution plan relating to the corporate debtor does not discharge the liabilities of the personal guarantor to the corporate debtor. They raised the violation of Article 21, the liberty to have my own property, right to liberty, to have my own property. The apex court said that look, the personal guarantor's liability is not discharged with the approval of the resolution plan. That is totally different thing. We will discuss subsequently that it is more so because of the provision in the contract. So Supreme Court iterated that there is sufficient indication that in the code, as can be deduced from section 2E, what we have seen, that applicability of the code 525 22 subsection 22, section 5 section 22, which deals about the definition of the personal guarantor, section 60, that authority of the adjudicating authority, that is NCLT, and section 179, adjudicating authority of DIT, that personal guarantors were to be dealt differently compared to the other individuals. So the violation of Article 14 does not arise. It held that section 2E, which deals with the application of the code of personal guarantors to corporate debtors, as was amended to take retrospective effect, did not suffer from any non-application of money. So this is the observation of our apex court. Involuntary act of the principal debtor which leads to the loss of security does not absolve the liability of a guarantor, and the liability of the guarantor would very much continue, and the creditor can still realize the same from the guarantor in terms of section 128 and section 134 of the Indian Contract Act 1872. We'll discuss it soon, friend, but section 128 and section 134 deals with the liability of the guarantor and surety. And the apex court said that it is open for the financial creditor to realize the money from the guarantor in terms of that section 128 and 134. Next, that apex court has dismissed the application petition filed for the constitutional validity of the code and put its seal on the applicability of the notification. So friend, if you see that process of personal guarantor, it is applicable in 2 stages, like CIRP also. You know, first is the insolvency resolution process, and it covers section 94 to 120 of the code. Resolution application rules 2019 and insolvency process regulations 2019. So these documents, they are meant for the insolvency resolution process for the personal guarantees. Stage 1. If it is not done or if it is failed, then come to the next stage, bankruptcy process, if required. This is sections, this covers under the sections 121 to 178 of the code. Then there is a separate rule, bankruptcy application rules 2019 and bankruptcy process regulations 2019. So under these two stages, the process to personal guarantors are governed. Now come the question, who is a personal guarantor? You know what I said, that notification also amended the definition part of the code, that is section 5 subsection 22. The section 5 subsection 22 of the code, personal guarantor means an individual who is the surety to a contract of guarantee to a corporate debtor. It is defined the personal guarantor as a surety in a contract of guarantee to a corporate debtor. When bank gives loan to the corporate debtor, generally they take the security, of the assets. The corporator has to make charges against their assets. Also, sometimes bank, what happens, they take the guarantee from the renowned persons who stands as the surety or guarantor for the corporate debtor for the repayment of the loan by the corporate debtor. So section 522 of the code said personal guarantor means the individual who is the surety in a contract of guarantee. Definitely bank execute the contract of guarantee with that person. Now here comes the section 128 of Indian Contract Act. As per Indian Contract Act section 128, it says the liability of the surety is a coextensive with that of the principal debtor, unless it is otherwise provided in the contract. What I said, that when bank accept the guarantee from a person for the loan granted to the corporate debtor, bank generally execute an agreement, which is called guarantee agreement with the person. So section 128 of Indian Contract Act said that the liability of surety or the guarantor who has given that guarantee, it is coexisting with that of the principal debtor. The guarantor or surety is also equally liable for the payment of loan to the bank, but is also observed by the working committee. So because they on the basis of their guarantee, the bank has extended the loan to the corporate debtor. So unless it is otherwise provided in the contract, if it is mentioned something else, then generally some conditions are given in the contract that if there is change variation in the terms of the lending without the consent of the guarantor, then the guarantor is not responsible. Blah blah blah. So unless and until it is provided in the contract, the liability of the guarantor is coexistent with that of principal debtor. There is a case law, friend. It is called. The name is Ramkishan versus State of Uttar Pradesh. It is decided by the Supreme Court, but it is related to the Indian Contract. It is not for the IBC. So for your reference, I note down the judgment of this order. It mentioned the liability of guarantor stroke surety is coexistence with that of the debtor. Creditor has a right to obtain a decree. You know, decree is the action available to the petitioner against a judgment. So it said that the creditor has a right to obtain a decree against the surety and the principal debtor. For both, they have the right to take action. surety has no right to restrain execution of the decree against him until the creditor has exhausted his remedy against the principal debtor, for the reason that it is the business of the surety or guarantor to see whether the principal debtor paid or not. Apex Court categorically said that surety or guarantor cannot say that you first exhaust your remedy with the principal borrower, then come to me. They said no. They are parallelly liable. They are parallelly responsible for the loan given to the principal debtor. So they cannot say that you first exhaust the remedy and then come. So this is the decision judgment of Supreme Court in Ramkishan versus State of Uttar Pradesh under the contract act. So for
Sir,
your
may
reference.
I ask a question?
Yeah, please tell me. Hello.
Sir, under section 140 of the Contract Act,
Yeah.
there is a right of subrogation available to the surety.
Yes.
That if he is to make payment on behalf of the debtor to the creditor,
Huh.
then he subrogates into the steps of the creditor and he becomes a creditor and he can recover it from the principal debtor.
Absolutely.
But now in IBC,
Yeah.
whether the company is handed over to resolution applicant through CIRP process,
Right.
or suppose the company is liquidated,
Yeah.
the right of subrogation, which is a statutory right under the
Mhm.
Contract Act,
Yeah.
is lost. So how that right is protected within the scheme of IBC, or there is a lacuna in it?
No, actually, I told you that IBC has, first of all, IBC has an overriding power. If anything is not in consistence with IBC, IBC can override this. Okay. So now what you say about the section 140 of the Indian Contract Act, definitely is not inconsistent with the IBC. So one cannot take any actions under IBC, under the scope of IBC. Anything to be taken, any action to be taken, it is understood should be under the civil law. You get my point?
So
So IBC,
does that
IBC,
mean? So
yeah, tell me.
does that mean the provision under section 140 becomes redundant for the personal guarantors?
No, not absolutely not. Because
So under the civil
yeah,
law, suppose the
yeah,
company corporate debtor for which the individual is standing a guarantee is handed over to the resolution applicant.
yeah.
So how this surety can now proceed under the civil law against the corporate debtor because it is a clean slate theory?
Again, there is a point. When the resolution plan is approved, there are many things, that many things are mentioned there. So if it is mentioned that all these things will go on for a toss, the RPA is not responsible for these things, and it is approved by the COC and adjudicating authority, then absolutely nothing can be done. You are right. I agree with you. But if it is otherwise, if some action is given against them for these things, then it can be done. When that's why when in RBC you also know that when the resolution plan is approved, there are lots of litigation because of this. So that surety, the grantor, they can file the application. And I believe there are some petition also filed for this, where the court categorically said that basically this provision has come into picture, and also it is approved by the Apex Court for the maximization of value of the financial of the assets, so that the more credit is available in the hands of the banks and financial institutions.
So
So
there is
with
no
this,
doubt
so
about that.
this is totally, I mean, in conventional object, isn't it?
But that means the statutory right of subrogation that just becomes redundant. So,
I don't say it is
so the
redundant.
guarantor has lost that right.
It depends on anything. It depends upon the provisions in the resolution plan. It
No,
depends
in
upon,
resolution plan about the guarantors, there is nothing mentioned and nothing is permitted to be mentioned,
yeah,
because after the resolution plan, now the banks proceed against the personal guarantor to recover the rest of the money,
right,
right? And they
right.
are, in many cases, they are able to recover some money from the personal
Personal,
guarantors.
right,
Now the personal guarantor should step into the shoes of the principal debtor,
yeah.
of the creditor, not the debtor. Should step into the shoes of the creditor by
Yeah.
virtue of section 140 of the Contract Act.
Yeah,
But because now the corporate debtor is not there for which he stood guarantee,
right.
so his
So
right
if
is lost.
yeah. So if it is also, if it is also approved by the adjudicating authority, then according to me it is lost. You cannot do anything. According to
Anyway,
me.
please go ahead.
No, but one thing I want to mention it here. Sorry, I forgot to mention it earlier. You know, there is again another SLP file before Supreme Court by these personal guarantors, and it is still
Yeah,
under
I know. I'm
construction.
aware. That's Anil Ambani's case.
And it is for the section 97, 99, all these things.
But it doesn't cover the right of subrogation. This petition, as far as I
No,
know,
but
this
they
issue is
mentioned that
not before the Supreme Court.
no, but they said their right is affected. No, they said that because of this, their rights are affected. So and also Government of India, Supreme Court has sent notice to Government of India.
I
So
know.
maybe it will be clear when the judgment will come.
Let's
But
hope.
presently, what's happened, what you say, I fully agree to. Unless and until, since the IBC has the overriding power, unless and until mentioned, that they can't enforce. Even if it is enforceable, it is enforceable under the civil, not under IBC.
No, civil proceeding he cannot take because the corporate guarantor is already now the corporate debtor is no more.
Yeah, that is that. Yeah.
Anyway, go ahead, sir. Thank you,
Yes,
sir.
yes.
Thank you.
So this is the case for under concern. Right, good. So now if you see rule 3E of the personal guarantor application rules, it defines guarantor as a debtor who is a personal guarantor to a corporate debtor, and in respect of whom the guarantee has been invoked by the creditor. Sir, here there is also a point, you know what's happening. Personal guarantor has given the guarantee for the loan. That doesn't mean that he is liable to make the payment. Obviously, I mean, bank will do that, but the main prerequisite condition is the bank has to invoke the guarantee, and that should be as per the guarantee agreement. So the bank has to invoke his guarantee as per the guarantee agreement. Then only his liability to pay the bank will come. And remains unpaid either full or in part. Definitely, I mean, when the bank invoke his personal guarantee, the banks generally give some time. I think it is also mentioned in the guarantee agreement. So if it is not paid in full or it is paid in part, then the action can be possible against the personal guarantee. So circumstances on which the guarantee can be invoked, invocation as per the terms of guarantee contract in accordance with sections. Sir, here that 140 is also covered. In accordance with sections 126 to 147 of the Indian Contract Act. So I think there is a scope for them to file the petition, because it is in the code itself it is mentioned. So that the invocation of the guarantee should be done according to section 136 to 147 stands for the contract, liabilities and duties of the surety and guarantor. So the invocation should be done as per the provisions of this section. Okay.
Yes, please.
So after discussing all these things, I want to ask you one thing. Just tell me, what do you feel that can the guarantee be invoked before claiming the same from the corporate debtor? Just tell me yes or no. I cannot access the chat box. I don't know. What do you think, that can the guarantee be invoked before claiming the same from the corporate debtor?
Yes, simultaneously it will go, sir.
Yes, it can be.
It can be, or it can be done
It
parallelly.
can be. Sir, it can be, because the guarantee is coextensive with that of the corporate debtor. Liability is coextensive.
Absolutely. Absolutely. Right. Yes. So, Honorable NCLT in Vishnu Kumar Agarwal case, Vishnu Kumar Agarwal versus Messrs. Pyramid Enterprises Limited case, held that guarantee can be invoked before claiming the same from the principal debtor. This categorically stipulates the provision of Section 128 of Contract Act is also in consolation with the IBC. So NCLAT gave its decision that without claiming anything, without filing the CIRP petition against the corporate debtor, the financial institution can invoke the guarantee and claim the money from the corporate debtor. Both are the responsible to the financial creditors. Friend, here I want to discuss one very interesting case with you. It is NCLAT Delhi order, and from the date you can see that it is before that notification for personal guarantor came into the picture. In fact, this issue was raised from the very beginning of introduction of IBC. Whether the recovery can be, because of that haircut in the resolution plan, issue raised that whether recovery can be effected from the personal guarantor who has given guarantee for the loan. So in this case, Ferroalloys Corporation Limited versus Rural Electrification Corporation Limited, company application 80, insolvency number 92 of 2017, NCLAT Delhi decided as follows. The fact is that Rural Electrification Corporation Limited, REC, served as a financial creditor and had sanctioned a loan amounting to INR 517.90 crores to Thacker Power Limited. The principal debtor is Thacker Power Limited. Ferroalloys Corporation Limited, Ferroalloy was the corporate guarantor of the said loan and had therefore undertaken to guarantee all amounts payable by Thacker Power to REC. So REC gave loan to Thacker Power, and Ferroalloys is a corporate guarantor, give their guarantee to REC that about the repayment of the loan through the REC. When Thacker Power Limited failed to repay the loan, REC invoked the corporate guarantee against the Ferroalloys on 27th October 2015. Thereafter, the failure of Ferroalloys to repay the loan, REC filed an application under Section 7 of the code before the National Company Law Tribunal, Kolkata NCLT, to initiate corporate insolvency resolution proceedings against Ferroalloys. Because here REC step into the shoes of the financial creditor for Ferroalloys, though the loan is given to Thacker, because it is prior to the notification for the personal guarantors. NCLT passed an order in favor of REC admitting the application and appointed an interim resolution professional. Ferroalloys filed an appeal before NCLAT against the NCLT order. So now we see what's happening. So NCLT judgment is that NCLT held that a joint reading of the definitions of corporate person, corporate debtor, debt, claim, financial debt, operational debt, financial creditor, and default provides that a guarantee becomes a debt as soon as the guarantee is invoked, wherein after a guarantor, corporate guarantor becomes a corporate debtor in terms of the code. Code that sections are there but not notified. So they said that whenever the guarantee is invoked, it becomes the concerned guarantor becomes the debtor. In providing his judgment, NCLAT referred to Bank of Bihar Limited versus Dr. Damodar Prasad and another, which held that liability of the surety under Section 128 of Indian Contract Act 1872 is coextensive with that of the principal debtor. We already seen these things, provisions. Further, it was held that the court does not bar a financial creditor from initiating corporate insolvency resolution process against the guarantor who comes within the meaning of corporate debtor. So if the guarantor becomes the corporate debtor, the financial creditor can file the application petition against that corporate debtor, against that guarantor under section 7. So there is no bar according to NCLAT. In the absence of any express provisions prescribing inter se rights, obligations, and liabilities of a guarantor or financial creditor, it was held that the provisions of the Contract Act may be relied upon for the same. So they said, because the notification didn't come at that time, so they say that in the absence of anything, any specific provisions in the code, it can, the provisions of the Contract Act can be relied upon. So the application can be held. As such, it is always open to a financial creditor to initiate resolution process under section 7 of the code against a corporate guarantor, as the creditor is also financial creditor for corporate guarantor. NCLAT reliance on the aforesaid Bank of Bihar case, wherein it has been held that the liability of surety is not to be deferred until the creditor exhausts his remedies against the principal debtor. So now we see what Supreme Court says on this. Definitely appeal was made to the Supreme Court by the aggrieved parties, but Honorable Supreme Court also upheld NCLAT judgment by ruling that insolvency proceedings may be invoked against the corporate guarantor before proceedings against the principal debtor. It is possible. Supreme Court also said it is possible. The apex court reaffirmed a long line of precedents under Indian and foreign contract and insolvency laws, which hold that a creditor may be proceed against the guarantor on failure of the principal debtor to repay the loan upon demand of the creditor without exhausting his remedies against the principal debtor. If the argument of the appellants had been accepted, it would not only amount to rewriting the contract, but also reading provisions into a statute which is impermissible. It is impermissible. So Supreme Court said that, look, when the agreement was held between the guarantor and the lender, that is bank and financial, it is mentioned there that if they fail to pay, he will pay. So he is also a creditor. If the land is invoked, he is also becomes a creditor to that financial creditor, debtor to the financial creditor. Therefore, the argument that the court does not recognize the concept of corporate guarantor, along with the argument that the insolvency proceedings cannot be first initiated against the corporate guarantor without proceeding and exhausting the relief provided against the principal debtor, becomes redundant and was rejected by the Honorable Supreme Court. So Supreme Court didn't agree to this contention that first bank should try to recover the money from the principal borrower. They said both are equally responsible or liable to the bank for make the payment. It is pertinent to note that the Insolvency Bankruptcy Code Second Amendment Act 2018 amended the code to bring section 5, subsection 5A with effect from 4/4/21, which defined corporate guarantor as a corporate person who is the surety in a contract of guarantee to a corporate debtor. Section 60 of the code has also been amended to provide for the same adjudicating authority to deal with the insolvency resolution or liquidation process of the corporate debtor and its corporate guarantor. So both the things are now taken care of by the court by making the amendment, second amendment to the code with effect from 4th April 2021. So now we come to the point, who can file application? I said that now there are two stages. One is the insolvency resolution process for the personal guarantor, which runs from section 94 to 120, and another for the bankruptcy process, which is from 121 to 178. So as per the code, an application may be filed by the guarantor or debtor, either personally or through a resolution professional under section 94(1). So the guarantor or debtor can himself file the application for the insolvency resolution process. Application is to be filed in Form A, that is Rule 6(1). With application fees of rupees 2,000. And application fees of which they have to pay while filing the application. The application to be served to every financial creditor and the corporate debtor. So copy of the application will come to the corporate debtor, because to for whom he has given the guarantee, and also to the financial creditors. Application will provide information about associates, assets of guarantor and immediate family, spouse, dependent children and dependent parents, annual income, directorships, businesses, excluded assets, furniture and equipment necessary for domestic use, tools, vehicles, equipment for business or occasion, single dwelling unit up to cap with a cap 20 lakhs in urban area and 10 lakhs in rural area, life insurance policy, pension plan, personal ornaments for religious purposes, cap up to 1 lakh. So all this information are to be provided by the guarantor or the debtor who filed the application under section 94(1) in Form A. But the following persons are not entitled to make the application. Debtors shall not be entitled. Following debtors are not entitled to make an application. Who are they? If he is undisturbed bankrupt, undergoing fresh start process, undergoing insolvency resolution process, or undergoing bankruptcy process. So under these circumstances, debtors, they cannot file the application for the resolution of insolvency for the personal guarantee. Similarly, application may be filed by the creditor either individually or through a resolution professional or jointly with other creditors. 94 talks about the debtors can file. Now section 95 says that creditors can also file. So creditors either individually can file or through resolution professional can file or can file jointly with other creditors. Any person to whom debt is owed is called a creditor. No specified nature of debt. Any debt, be it financial debt or operational debt, any debt, they can file the application. Application is to be filed in Form C, Rule 7(2), with the application fee of 2,000. Invocation of guarantee is a prerequisite. But we have already discussed that if you want to file an application against a personal guarantor, prior to that action, the lender should invoke the guarantee, and ask the money from that personal guarantor. Only if debtor fails to pay within 14 days of service of demand notice, then it can be done. So 14 days notice period to be served on the debtor. The application shall be accompanied with the details and documents relating to the debt owed by the debtor to the creditors or creditors submitting the application for insolvency process as on the date of application. The failure of the debtor to pay the debt within a period of 14 days of the service of demand notice. So this demand notice and that there is no payment or part payment should be accompanied with the document. Relevant evidence of such default or non-payment of debt. A copy of such application shall be provided to the debtor. In case of joint application, the creditors may nominate one among themselves to act on behalf of all other creditors. So there will be a single point contract. So this is the procedure mentioned in the code for the applications filed by the creditors. So demand notice, if you see the demand notice filing, prior to filing of application, the creditor must serve a demand notice in Form B according to Rule 7.1. But they have to invoke their guarantee and serve the demand notice. The application can be filed only if the debt stated in the demand notice is not repaid by the debtor within 14 days of service of the demand notice. Unlike demand notice under IGBI application to adjudicating authority rule 2016, the demand notice in case of personal guarantor does not give a chance of disputing the notice. Friends, you know that in case of CIRP, the operational creditors is also required to file a demand notice or required to file a notice, serve a notice on the corporate debtor asking the payment of money or within 10 days of that notice. So after receiving the notice, the corporate debtor may raise the dispute of the transactions. And if it is so, maybe the application is rejected by the adjudicating authority. But here, in this case, when the demand notice is served on the corporate guarantor or the personal guarantor, there is no scope of dispute. Either you have to pay money within 14 days or the application will be filed with against the corporate guarantor by the financial creditor. So at the time of the argument of the petition, then you may prove that you have already paid the money or you are not liable to pay the money. But you cannot raise any dispute against the demand notice which is served on me after invocation of the guarantee. Now there is a provision for withdrawal of application also, which is also there in the CIRP. So as per Rule 11 of the adjudicating authority, Rule 11, the adjudicating authority may permit withdrawal of the application on a request made by the applicant before its admission. So if it is made before the application is admitted by the applicant, then the adjudicating may permit the application may be withdrawn in this case. Or on request made by the applicant if 90% of the creditors agree to such withdrawal after this admission. Either before admission you have to make the application for withdrawal, or if it is done after admission, then it must be approved by 90% of the creditors agree for the withdrawal of the application. And this application should be filed in Form B. Now you know what's happening after the admission of the application. Like CIRP also, a public notice is sent, is advertised for asking claim from the creditors. This is given under section 102, but unlike the RP, as per the code, the adjudicating authority the power is given to the adjudicating authority. The adjudicating authority shall issue a public notice within 7 days of passing the order, inviting claims from all creditors within 21 days of such issue. But in reality, friends, what's happening while passing the order for admitting the application, or adjudicating authority generally mention that the RP shall cause to publish a public notice within 21 days of the date of the order and make a copy available to the register of NCLT for displaying in the notice board. Sorry. So the notice, what is the content of this notice? The notice shall include the details of the order admitting the application, the order reference you have to given. You have to given the also the you have to given the reference of the corporate documents. The particulars of the resolution professional with whom the claims have to be registered and the last date of submission of claims. The notice shall be published at least one English and one vernacular newspaper which is in circulation in the state where the debtors resides, affixed in the premises of the adjudicating authority. What I said, that it will be published in the, it will be affixed on the notice board of the adjudicating authority, of the office of the adjudicating authority, and placed on the website of the adjudicating authority. So these are for the these are the provisions for the publishing the public notice for inviting claim from the creditors, and the creditors has to file their claim within 21 days of the issue. Then friends, here there are two types of moratorium. One is interim moratorium under section 96 and another is final moratorium under section 100. So when interim moratorium is made available, it is made available from the date of filing application till its admission under section 99. You know what's happened when the debtor or the creditor file the application. From the date till the admission of the application or rejection of the application under section 99, the interim moratorium will be in place. And what is the purpose of the interim moratorium? Is just against pending legal action with respect to any date, initiation of proceedings against any date. The pending legal action with respect to any date of the personal guarantor or initiation proceedings against any of personal guarantor, it is prohibited under the interim moratorium under section 96. No, after, you know what's happened after the application is filed under section 94 or 90 or 95. Either it is filed by the debtor or creditor by themselves, or it is filed by a resolution professional. But we have already seen when the application is filed by the debtor or creditor, then the adjudicating authority, that is NCLT, within 7 days asks the IBBI to nominate a person to act as the resolution professional. And IBBI within 7 days of that application, generally nowadays the list of the resolution professionals is made available with the NCLT. So one resolution applicant, resolution professional is appointed by the adjudicating authority or NCLT for under section 97 of the code. And it is the responsibility of the resolution professional to go through the application and to inform the adjudicating authority whether the application is filed to default the creditors if it is filed by the debtors or the personal guarantor, default the creditors, sorry. If it is filed by the debtors or personal guarantor, or whether this application is prepared in conformity with the provisions of section 95, where we have seen all these things is mentioned, that debt is notice, guarantee is invoked, notice is served, debt is unpaid or partly paid, all this information to be given in that 95, and the RP, it is the RP's duty to verify and report for these conditions. And if RP said that yes, it is done, then the notice is either the application is either admitted under section 99 or it is rejected under section 99. This interim moratorium is valid from the date of filing of application till its admission or rejection under section 99. Now, once this notice is admitted or rejected under section 99, then comes the final moratorium. This is under section 100. And what is this stands for? This form the admission of application till 180 days or approval of the repayment plan, whichever is earlier. This moratorium is valid. And this is for against pending legal action with respect to debt, initiation of proceedings against debt, like your interim moratorium also. And it is mentioned that debtors shall not transfer, alienate, encumber any of his assets or legal rights. So it is categorically mentioned by this final moratorium, total status quo is given to the position of the corporate guarantor or the debtor. No movement is possible thereafter when the final moratorium is imposed. So now we come to the repayment plan. Repayment plan section 105 is very much similar to the resolution plan in case of corporate insolvency. It is said to be the key to resolution in case of non-corporate insolvency. Resolution plan is the key to insolvency resolution for the company or the corporate debtor. And this here, the section 105 repayment plan is the key to resolution for the corporate guarantor. It is the plan proposal containing terms as per which the debtor, that is the corporate personal guarantor, will pay his debts to the creditors. It also provides the manner in which the affairs of the debtors will be carried out. Affairs of them means the personal guarantor, because personal guarantor, we have seen that personal guarantor have to mention it may have some other businesses, some other income. So how these affairs will be carried on, everything to be narrated in the repayment plan submitted by him. The features of the resolution repayment plan. So obviously it is will be prepared by the debtor in consult, but it should be prepared in consultation with RP. It contains the proposal for restructuring of debtor's debt towards the creditors. May authorize RP to carry on the business or trade of the debtor on behalf of his name. May contain justifications for preparation of plan. You know, definitely when the repayment plan is prepared, it is not prepared for the payment of entire debt or entire claim made by the financial creditors. If it is so, then it's well and good. But if it is not, then the necessary justification should be mentioned in the plan. And it is also one of the responsibilities of the RP to see that justification which is given is correct or not. It must state the reason by why the creditor may agree to it. This is here comes the responsibility of the RP. The repayment plan also mentioned that this is the reasons for which it should be accepted or it should be agreed by the creditors, because this best can be done by the personal guarantor to make payment of the claim. So these are the features of the repayment plan. Now, contents of the repayment plan, as per Rule 17 of the Personal Insolvency Application Rules 2019, the following are the contents of a repayment plan. Terms of repayment plan and the implementation schedule to be mentioned. Source of fund to pay the resolution cost. minimum budget for duration of the repayment plan, finance required for implementation of repayment plan, variation of onerous terms of a contract or transactions involving the guarantor. It is not only the payment, the corporate guarantor can also ask for the variation of the terms of the contract, which he has with the financial creditors. And that is also possible. They can mention that, look, I buy this after this payment, this thing to be changed to these things. Details of excluded assets and excluded debts to be mentioned. We will discuss about what I mentioned meant by the excluded assets or excluded debts of the guarantor, and terms of conditions for discharge of guarantor. How the guarantor will be discharged from his responsibility. It is also the terms and conditions related to that should be mentioned in the repayment plan. So these are the contents of repayment plan as per Rule 17 of the Personal Insolvency Application Rule 29. Now comes the approval of repayment plan. The repayment plan shall be approved by a majority of creditors having more than 3/4 of value, that is 75%, who are present in person or by proxy and voting on the resolution in a meeting of the creditors. So once the repayment plan is submitted, it should be placed before the committee of creditors, and the plan should be approved by the creditors having 3/4 value, either who are present in person or proxy and voting in the meeting for the resolution. Now here I am showing you two cases, two scenarios.
Sir,
For the
just a
approval
minute.
of the, sorry, hello?
Yeah, sir. Sir, here you said the COC. So in the personal guarantor cases, you understand there would be definitely personal individuals also, matlab operational creditors in our language, or because since it is a personal guarantee, there would be long number of individuals also who must be owning, I mean, to whom this guy must be owning. So
Yeah.
would they also might file all their claims in the process.
Right.
So what is the constitution of the COC? I'm trying to understand that would every guy who has put a claim, because here, I mean, like we have financial creditors, operational creditors defined under CIRP. Is there such a definition in personal guarantee?
No, actually, you know what's happened here? The resolution professional will call a meeting. The first meeting you have to call for the all creditors. Okay. But in that meeting, the committee of creditors will be decided. So there, the resolution professional should discuss with the creditors. You are right. That is the problem. So how the committee of creditors will be decided? It will be fixed in that meeting. But when this meeting comes, it suppose they said that with this this person will represent me. So this percentage will be calculated for the entire claim for the persons who present in the meeting, or either by himself or by proxy. Am I clear?
Yeah, I mean, so I'm just to or what I have understood from you is that as we said that there will be 21 days given time for filing the claims.
Yes.
So in that, say individually, you, me also, like our individuals, and we might have filed our claims, and there will be definitely banks who have filed their claims.
Right.
So in the first meeting, it will be a meeting where bankers also would be called, then you personally, me personally, all
the creditors will be called.
all. So that would be a huge kind of a number, and in that we would have to propose that the individuals may nominate somebody either from themselves or may, I mean, I don't know. Then is that what you are trying to say?
Yes, they'll nominate somebody for to constitute the committee of creditors.
So is that the guy, that nominated guy, need to be an RP in the sense AR, what we call our authorized representative? So that authorized representative has to be a insolvency professional, or it can be an individual, any individual.
Not for this insolvency resolution for the personal guarantor, but What you say is mentioned in the code for the bankruptcy. You know the creditor base. I will come to this point. You just keep it in your mind. I will come to this. I will come to this point in the subsequent. Okay.
Okay.
Just keep it in your mind. I will come to this point. So case one is the case is that in a situation claims have been received from 10 creditors of total value of rupees 10 lakhs. Now the repayment plan is placed before the creditors for approval. In the meeting, out of 10, only 6 creditors having claim of 3,50,000 are present and are entitled to vote. Okay. So scenario 1, 3 creditors, 6 come with the value of 3,50,000. Total number of creditors 10 and total value is 10 lakhs. Now scenario 1, 3 creditors having claim of 2,75,000 present, vote by approving the plan. The vote in favor as a percentage of total claim is 27.5. How it is calculated? 10 lakhs, 2,75,000 out of 10 lakhs. So you see that the total vote given in favor of approval of the plan is only 27.5, whereas the percentage of the vote is 79%. How it is clear? This 2,75,000 out of 3,50,000. So
Sir,
it is
I have a doubt.
Yes, why?
May I raise a doubt, sir?
Yeah, tell me.
Sir, in section 111,
Yeah,
the requirement is that repayment plan should be approved by the majority of more than 3/4 in value.
right.
That is a mandatory condition. And
Sir,
how come with
it is also
27.5%
mentioned,
the resolution can be approved?
sir, it is mentioned also who are present in person or by proxy.
That's right. But along
So,
with that, it is also mentioned that 3/4 in value.
because
So
value
if
present and
3/4 in value are not present and they are not voting, then resolution cannot be passed.
no,
Here
sir.
only 35% are present.
Sir, just a minute.
In the example, only 35% are present, whereas 75% should be present as per provision of
I
111.
agree, sir. Sir, just let me open that section 111.
Kindly see, I can read section 111. I have with me.
Just a minute. Just a minute.
The repayment plan or any modification to the repayment plan shall be approved by a majority of more than 3/4, more
Ah.
than 3/4 in value.
Ah.
So it is more than, that means it should be 76%.
7 more than, yes.
More
Comma.
than cannot be 75. It should be at least 76% and
No,
76
75 more than 3
present in
75.
voting.
Yeah. More than is there, yeah.
Yeah, more than 75%,
Ah.
and they should be present and voting. So in this example, only 35% are present and voting.
And they are present and voting.
That's what I'm saying, sir.
So if they don't come,
75% should be present and voting.
no, sir, if they don't come, suppose that's what I'm saying. Suppose there are 10 creditors with 10 lakhs value, but they come only for 3,50,000. So this 75% will be calculated on the 3,50,000, not on the 10 lakhs.
No, it says
And
more than 3/4 in value of creditors.
sir, both the
The value of creditors is 100 and
sir,
76% should be present and voting.
I agree, sir, but in that case, both the conditions to be fulfilled. The and it is
Both the
mentioned
conditions,
and.
correct. Both the conditions are to be fulfilled.
So it
So
will be
one condition is more than
75% and they should
75%.
come and present and vote.
So more than 75% should be present and voting.
So more than 20.
So here in this example, only 35% are present and voting.
So vote is more than 75%. But when the
No,
that's what I'm saying that
Resolution has-
तो बढ़िया 2003 की डाल रहे हैं एंट्री सी
hello, can I request some
सर के पास जा रहा हूँ
please mute yourself, please. So sir, here my point is that
सर इसमें 10
और
लाख
क्या हाल है
के
गोपाल
टोटल
sir, please mute
10 लाख
yourself,
के
sir.
ये चीज की मिठाई
हैं,
बांट
से
रहे हो
सिर्फ 3.5 लाख प्रेजेंट है तो 35% हुए।
8800
सेक्शन की रिक्वायरमेंट के हिसाब से
18
मोर देन 76%, 75%
दीपक।
प्रेजेंट इन वोटिंग।
Yeah. Now, according to my interpretation, sir, we will discuss it later. Maybe after the presentation, we will discuss.
Okay. Kindly
So
go ahead.
what, according to my
2003.
interpretation, sir, can I request you to mute yourself, please?
Sir, admin can mute all. Admin, please mute all.
So,
Miss Suchi Agrawal.
आ गया
so what I interpret, sir, maybe we'll discuss it later, that
Okay.
since
Okay.
and is mentioned, it have to fulfill both the conditions. That is, you should come for the meeting either in person or through proxy. That is, the proxy is also mentioned. They said you have to come, and then the more than 75% should cast vote in favor of the repayment plan. You know, I frame my argument because of the word mentioned proxy also in this section.
Sir, the section says 3/4 in value of the creditors present in person.
Present
or
in
proxy.
person or by proxy.
So 75% should be present.
So this is more important. The presence of the creditors in the meeting is
Sir, is
more
it not the
important.
75% who is present in the meeting or on the total one?
Present
Not
in
on the total 75% who are present in the meeting, right?
Present, the persons who are present in the meeting, they
Yes.
out of that 75% should approve.
Yeah, exactly.
That is my interpretation.
Yeah,
Maybe
yeah, that's
Dr. Chukral is differing with me, but we'll discuss it.
Yes, I agree with you, sir. Partha Kamal Sen.
So here, though, I fully agree with you, sir. That though it is, that's why I mentioned these things in my presentation also. Though the value in favor of approving is only 27.5, but because of this provision, the present and in person or proxy, the voting percent has gone to 79%. So the second scenario is that out of these three creditors who voted in favor of the plan, 2 were present in proxy. In that case, also the plan is approved, because it said that either in person or by proxy. So in under both the scenario, the approvable plan is approved by the COC. Now, once the repayment plan is approved by the creditors, the RP is to submit the plan along with his report before adjudicator authority for its approval. Repayment is to be filed by RP. Hello? Is somebody want to tell something?
क्या है इंडियन इंस्टीट्यूट वाले
Can I please request you kindly mute yourself if you are not talking to me? Otherwise, okay, thank you. Repayment plan is to be filed by the RTO with adjudicating authority on or before 120 days from the commencement date. So before 120 days of the commencement date, the repayment plan has to be filed by the RP. Otherwise, the process will be terminated. The AA shall by order approve the repayment plan on the basis of the report of the meeting. When no meeting of COC is summoned by RP, because here RP has the power, he can say that, look, this is the repayment plan. Suppose the repayment plan say that everything will be paid to the creditors. So there is no requirement to summon the COC meeting. So when no meeting of COC is summoned by RP, A shall by order approve the plan on the basis of the RP's report on repayment plan. So these are the provisions for the repayment plan approval. On the basis of the repayment plan, the RP shall apply to AA for a discharge order in relation to the debt mentioned in the repayment plan, section 119. Here I go back to the question which someone of you raised. You know, last time when I make the presentation on this subject, there was an intense debate whether the creditors who filed their claim as per the advertisement made under section 102 are the creditors only related to the corporate debtor for which whom the personal guarantor has given the guarantee, or it is the entire creditors of the personal guarantor. I mean to say that whether it is the creditors will be debt specific or it is person specific. After the last seminar, I gone back, I studied the provisions, I did research, and I reiterate my opinion that for the personal guarantor case, the creditors who can file their claim is the debt specific. It is only the creditors related to the corporate debtor for whom the bank guarantee, the personal guarantee was given to the banks, which is invoked. But for the purpose of bankruptcy, it is the person specific. Because if you see, it is the in bankruptcy case, the person is discharged from all his insolvency debt. The word which is used here is that he is discharged from all his insolvency debt. But here the person is only discharged related to the debt. So if you have any other view, we can discuss it here.
Sir, in that case, so my question which I asked just 10 minutes ago goes for a toss, because the basically question which I had asked was the same question, that there would be individuals, as I understood that it is a person specific. So as a person specific, he would have personal loans and personal, I mean, individuals involved. But if we are then talking corporate guarantor, CD specific, then it would be generally, and in 99% cases, it would be only a banks or financial institutes, at the most few operational creditors.
Obviously.
But he, in fact, not even operational creditor, because he would not give a personal guarantee to an operational creditor. So that means he has given a personal guarantee only to a bank, that is in a normal circumstances. So are we then saying then there is actually no, I mean,
no, I slightly differ with you. I here mentioned that the operational creditors related to the corporate debtor can also file it.
But he has not given
Because
any personal guarantee to them.
repayment plan is for to establish him. It is not the he said that I will pay everything. In repayment plan, he mentioned all his source of income, his assets, everything, and out of which he said that by this way I will pay the banks, financial institutions who has invoked my guarantee. But while prepare the repayment plan, he has to consider all his debt related to that corporate debt. You get my point?
But see, that's what I'm trying to say. He has not given a personal guarantee to the operational creditor. Obviously, if आपने किसी से purchase किया है, so you have not given to that creditor any personal guarantee. So if I have, it's like if I have not given you, between you and me, if I can say, if I have not given you any personal guarantee, why would I consider your liability to me?
Otherwise, how can
you go to the CD, na? You go to the CD for the CIRP. I am not liable to pay you. That's what I'm trying to say.
How can you exhibit in your through your repayment plan that you have the means to pay the financial creditors? How can you?
But it is only to the bankers. So my repayment plan should then just satisfy the bankers whom I have given guarantee. In fact, in that case, a step ahead, there could be two bankers whom of which I have given guarantee only to one, and other if I has not taken any personal guarantee for me, then in that case I should not be paying to that other banker also, because I have not given any personal guarantee to you.
No, sir. I beg to differ. Here, what's happened here? The purpose is that suppose a bank, suppose I mean for hypothetically take the example that State Bank of India invoked the bank guarantee, personal guarantee of Mr. X. So
Correct.
they are giving loan to X company. Okay.
Sir, one
Now,
question.
just a minute. Now, State Bank of India will file the application either
Correct.
jointly with other creditors or as a State Bank of India. Now, when their application is approved under Section 99, the approved, then adjudicating authority will ask the resolution professional to ask for the repayment plan. And in the process 102, the court said that of course the adjudicating authority, but it is given, the charge is given to the RP. The RP should make an advertisement and ask for the claim for the creditors related to X Limited. It never says that you only ask for the, if you see the form for the public announcement, it mentions that this order has been passed against X Limited. Who are the creditors for X Limited should file their claim. So it never says that only the financial creditors for whom he has executed the bank guarantee should file their case. But suppose UCO Bank, he also has the same personal guarantor, but he has given his guarantee for Y Limited. UCO Bank is not entitled to file his claim for the advertisement made for the X. Am I clear?
Okay, I understood your point, sir. But in that case, in a practical life scenario, one personal guarantee can never be good enough to cover the company's total liability. So because when you add up,
that's what I'm saying, that there is an intense debate, I'm telling you. And I have gone back, I have studied. For the insolvency resolution of the personal guarantor, it is not. But for the bankruptcy process, it is yes.
no, I understood your point. I understood your point. Now, what I'm taking that point forward, that now in the repayment plan, we are saying he has to show how he will repay all. Now, in that sense, a personal guarantor's net worth cannot, I mean, generally cannot be that big that it covers the entire liability of the corporate debtor, because it, as we are including now the operational creditors, and generally operational creditors are many, like in big companies, there are huge number of amount of operational creditors.
Right.
So my repayment plan would never ever be able to satisfy the whole lot of creditors.
If it is not satisfied, then it will be rejected, and the next step is bankruptcy, like liquidation. That's why I'm saying that there are two phases in this process, phase 1, phase 2. So when you are going to resolve the insolvency for the personal guarantor, it is not required. If you see the content of repayment which is given under Rule 17, it is categorically said all these things. The sources of fund where he has get the money to pay. But if he failed to mention, if he doesn't have sufficient fund, then he will go to bankruptcy, which is as good as your liquidation for the corporate debtor. But you cannot say that when you make your repayment plan, because repayment plan is only discharge me out of the debt which I have incurred to the financial creditor who has invoked my personal guarantee. So you cannot say that my repayment plan will include all my creditors, and then I will prepare then there will be no repayment plan. I mean, feasible repayment plan is available for this.
Sir, I have one doubt, sir. Actually, suppose the CD's CIRP plan is approved and the bank is recovering 100%, whereas the operational debtors, they are being given only 10%. The remaining operational debtor, can they request the bank to initiate the bank guarantee of the promoters, so that they will get money from the personal guarantee executed by the
I don't think so.
Executed with the bank?
No, because you have seen that application to be filed under Section 95, they have to mention that how much is the amount and how much is the paid. So if you show that 100% for my claim is paid by that guarantor, then your application will be rejected.
No, anyhow, the CD's creditors is unpaid.
No.
CDs,
Ab-
operational creditors
I
is still
agree,
unpaid.
but no, they have to go for the CIRP process. This personal guarantor route is only made available for the financial banks and other financial institutions, which we have also
Okay.
discussed. Now, this is
Huh.
the objective of the working committee also. Otherwise, so I mean, the entire part 3 can be notified. Part 3 not notified because of the fine infrastructure issues are there.
Suppose,
But out of that, personal guarantor thing is notified because of that.
suppose the banker's liability is around 99% settled, 1% outstanding. So the financial creditors goes for recovery of the 1% amount.
Yes, yes.
That time the operational creditors can join to claim the amount. Is it? Am I correct, sir?
No, they come and join. Definitely, they will submit the claim, but the repayment plan will only show how the person will pay that 1% of the financial credit. That is my interpretation. Because then if the company goes, because first of all, sir, try to understand one thing. IBC is not meant for recovery. IBC objective, I have shown you the objective. The main objective of IBC is to first make the resolution of the distress things, and if not, then you send it to the liquidation. There is no point of recovery. We very loosely said that financial creditors recover these things, all these things, but IBC, objective is not make for recovery. What you are scenario where you are telling, then the operational creditor let them go to the civil court. They can file their application there. But
No,
not,
so then, sorry to interrupt, but yeah, so then in that sense, what did you say? They will, the operational creditors will file their claim, but the repayment plan need not show how they will be repaid. That's what are you saying?
yes, repayment plan will only show how the debt of the financial creditor can be paid.
So then why would the operational creditors file the claim in first place? If I am not going to get any amount, why would I file any claim?
If you don't file, then you don't file. But if you file, then your claim amount should be considered in the repayment plan of the personal. Sir, if you don't file your claim, you need not to file.
No, I'm asking if you are saying the repayment plan will never pay the operational creditors.
Yeah.
See, if my plan has to just show that how I am satisfying the financial creditor, that means I will never practically no person would pay any amount to the operational creditor. Is that a logical sense?
Not the personal guarantor. At the not the personal guarantor and in the personal insolvency resolution stage. But the operational creditors definitely can recover their money if it is available during the bankruptcy stage.
So bankruptcy, no. So we are not discussing bankruptcy because which is not there, which is not notified.
For personal
So let's not discuss that.
For personal guarantor insolvency resolution things, repayment plan only indicates how the money for the financial creditors will be satisfied.
So that's why I'm saying if that is only to be shown in the repayment plan, the guy would never ever pay a single rupee to any operational creditor. Correct?
Yeah. Through the repayment plan, yes.
Through the repayment plan. So
yes.
Through the repayment plan, if he is not paying to the operational creditor, then why would the operational creditors file their claim in that first 21 days?
No, so there is no hard and fast rule that the operational creditor should file the claim. If they don't file, then their claim will not be considered in the repayment claim. That's all.
But even if they file, they are not going to be reconsidered. That's what I'm trying to say.
Even if they file, then their claim will be considered, and the repayment plan will be prepared accordingly, and the person will be discharged or not. You know what's happening? Suppose the repayment plan failed. There is no repayment plan. The bankruptcy is not automatic. Unlike your liquidation, where the resolution plan failed, the adjudication ordered for the liquidation. But here again, if the application is rejected or the repayment plan is not, there is no repayment plan, or the repayment plan approved by the AA but not implemented fully, then the process is terminated, process is stopped. Then the creditors again have to file the application for bankruptcy. It is not automatic. So when financial creditors file their application for bankruptcy, then okay, the question of operation payment to the operational creditors will also come. It is my personal interpretation, but I interpret it this way. Personal guarantor resolution only restricted to the payment made to the financial creditors for whom he has given the guarantee to the corporate debtor on behalf of the corporate debtor. While preparing the repayment plan, adjustment made, maybe operational creditors will also file their claim, but a repayment plan will consider the claim, but it will only show how the payment to the financial creditor will be made. If the repayment plan fails, the next step is the bankruptcy. That is another set of process where the separate application to be filed by the financial creditor, and we will discuss how the process will continue. Yeah.
Sir, may I?
Yeah, sure.
Sir, in one of my company is under CIRP, and IRP has been appointed. And we have also filed application under section 95 to both the directors for personal guarantee.
Okay.
Sir, in that case, that operational creditor are allowed to submit the claim to PG also, in the RP also for the PG and to the CIRP also?
Yes, CRP definitely yes. CRP to operational creditor, they will file their claim.
Yes, yes.
But for PG, the operational credits are related to that CD will file their claim.
Okay. Okay.
Not the other, because personal guarantor is a person.
Yes.
So apart from his creditors of the CD, he may have his own creditors.
Okay.
Who are not related to the CD. So those creditors, that's why I give the example now. Suppose State Bank of India has given loan to X Limited, and Mr. Y is a personal guarantor given guarantee to SBI.
Yes.
SBI invoked the guarantee, and then the insolvency resolution process for Mr. Y is started. Okay. So public announcement is made. Definitely, X Limited will file this claim, and all the creditors related to X Limited will file the claim. Okay. Because this process is related to the debt of the corporate debtor. But suppose Mr. Y has given his personal guarantee also to UCO Bank for giving their loan to Z Limited. Okay. Mr. Y is also liable as a personal guarantor to UCO Bank, but that is for the different corporate debtor. Even if UCO Bank invoke its guarantee, but UCO Bank cannot file his claim for the advertisement made by the RP under section 102 for the CD X.
Thank you, sir.
So anybody wants to, but I think we are also running short of time. So I can discuss with you later on also. I think in the slide you will get my contact number, everything. We will discuss it. But this is my interpretation. So again, I reiterate that for personal guarantor insolvency process, it is debt specific. But for bankruptcy process, it is person specific. Yes, tell me. Somebody wants.
In this process, the bank is recovering portion of its amount. And will they modify the claim with the RP that my due is reduced to that extent like that subsequently, or they will still continue the
No. They can't. They have to modify. They have to modify their claim. Even if suppose the bank has filed the application against a personal guarantor, but subsequently he has recovered something through the resolution plan, he has to modify his application against the personal guarantor. He cannot continue with the same claim. Because you know what the access both the principal borrower and the corporate guarantor are responsible for the financial claims. Jointly, it is joint responsibility. So shall I continue? Hello?
Yes, continue, sir. Continue.
Or anybody has any question? I think there things will be more clear when I will discuss the bankruptcy process. So I just go a little bit fast. The A may pass the such discharge order. Rule 21 says the repayment plan may provide for an early discharge or discharge on complete implementation of the repayment plan. Both things is possible. That's why again I stick to my stand that here the entire process is the debt specific, not the person specific. Because here say that early discharge is also possible. But in bankruptcy, you see the period is mentioned either 1 year or the completion of the administration. Then the only person will be discharged. Discharge order shall not discharge any person from any liability in respect of his debt. It is only, that's why again I am saying, it is only mentioned that only particular this debt is being discharged, not from any other liability. So it is the timeline for the processor. If you consider T0 is the date of filing of application, which is the commencement date, then A to board for appointment of, I say that there are two ways, I mean, to file the application, either through RP or both the debtors or creditor can individually file their application. So if it is not through RP, then T0 plus 7 means from the date of filing the application plus 7 days, the adjudicating authority should write to IBBI for the appointment of RP. And this T1 plus 7, the IBBI will appoint an RP. IBBI will give the name of the IP. RP, generally nowadays it is a panel, and within T1 plus 7, the adjudicating of authority will appoint the RP. Now T3, that this T2 plus 10, RP to submit report under section 99 to adjudicating authority on admission of the application, which I've already told you that RP to see whether the application filed by the debtor to default its creditors or creditors have filed the application under section 95 which comply with all the provisions mentioned there. Then only the admission of the application can be happened. So T4 is the T3 plus 14 days, the order passed by adjudicating authority, either admission or rejection of the application. Note, in case of non-admission, creditors are entitled to file bankruptcy application against the personal guarantor. Look, friends, it is categorically said, even if for some reason the application for creditors where he wants to recover his dues is failed, it is open for the creditors to file the bankruptcy application. T5 is T4 plus 7 is the public notice, which I have already discussed, 102 section. Then T6 is T5 by 21 claim receipts, that also have discussed. Then T7 is T5 plus 30 days, creditors list to be prepared by RP. Then T8, T6 plus T plus 21 days, receipt of implement plan from PG and submission of report under section 99 to adjudicating authority by RP. RP is required to file another report to adjudicating authority under section 99 by submitting the repayment plan received from the personal guarantor. Note, in this report, RP may recommend with reason that a creditor's meeting is not required to summon. Otherwise, the report shall specify the date and place of creditor's meeting for repayment plan approved. T9 is T0, that is the commencement date plus 120. So from the date of filing of application plus 120 days, submission of creditors approval for repayment plan to adjudicating authority for approval by RP. It must be done. And T10 is T0 plus 180. Within 180 days, the final order of adjudicating authority will come. So the entire process runs from will be completed within a span of 180 days, and there is no provision for extension of time. Okay. So now we go to the provisions for bankruptcy. Can you have 5 minutes break here? Just 5 minutes. Hello?
Sir,
Hello?
10 minutes. Sir, 10 minutes.
10 minutes.
Sir, 10 minutes.
We have anything to discuss. Make it 5 minutes, please.
10 minutes break will take, sir.
8 minutes break will take. Okay.
11:45 we come back.
Okay. 11:45 will come back. Okay. Done.